We are in the age of technology, and with our constantly evolving and adapting devices, the government should evolve too. The Fourth Amendment allows the government to use certain technology, i.e. drones, cell phones, GPS, within jurisdiction to protect and serve the American people.
What is the Fourth Amendment? The Fourth Amendment states, the right of the people to be secured in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons and things to be seized. Meaning that the police or any other government official are not allowed to enter your homes or property without a warrant from the court.
The Fourth Amendment was created to stop the raidings that constantly happened under King George III's ruling. America was still under the British rule then, and the king ruled all. Even though the people had their own homes and own possessions, his ideology was that since he ruled the kingdom, everything in it was all his. The raidings happened so frequently because during this time, the king used writ of assistance, which meant that they could raid anything they believed contained goods. Even though the people had to pay tax revenue to the king, those who couldn't pay were searched without any warrant or reason to be checked.
What is internet privacy, and what does it have to do with the Fourth Amendment?
Internet privacy is the amount of privacy that you can expect to have when using the internet. It can range from the things you post online to the kinds of things you buy on websites. Your internet privacy should only be known to you and should not be open to the public, especially if anyone might be able to find it using searches. Just like you wouldn't leave your house open to strangers, you wouldn't want to leave your personal data available for everyone to see. So the Fourth Amendment applies to your online privacy. This means that if a police or a similar institution wants to search your online presence, they must have a warrant from the court. Although, as to how flexible the internet is, so is law. Not all rulings are so black and white.
Recently, the police have been catching on to how effective the internet can be on the information available and have even been using it to solve crimes and help catch criminals. There are limits, though, as to what the police can use. For instance, without probable cause, the police may not track your phone to see where you are at any time. At least, this is what was ruled in the Carpenter v. United States case.
Timothy Carpenter had his phone tracked through transactional records by the FBI, which were used against him. From this evidence, they were able to see his whereabouts and caught illegal doings, so he was arrested. He pleaded that his Fourth Amendment was violated and it was taken to the Court of Appeals. The decision made by the court established that the warrant is needed to access any cell site location which is obtained from stored information in wireless carriers by a mobile phone connecting to a cell tower.
When signing up for apps or a new cell phone company or etc., we give consent to them once we click that button of terms and conditions. The government should be able to use that same exact information. But of course, the Fourth Amendment protects them from taking advantage of our information that we put out there without us actually knowing. Like in the Riley versus California case, the police went through a phone without a warrant, which is against the Fourth Amendment.
In the Riley versus California case, David Riley was stopped by the police for a traffic violation. His car was searched and he was arrested for weapon-related charges. He was investigated through his phone where they found videos and photos associating him to a shooting. Before he went to court, he said that the evidence was tainted because they had gone through his phone without a warrant and wanted it suppressed. All courts denied it and sentenced him to prison, allowing the evidence to be used. The court explained that warrantless searches could be done if they are reasonable.
To perform a search, the police needs one of the two, a warrant or a probable cause. We believe that in the next case, the FBI had probable cause, but it violated other people's privacy. In order to catch one person, others had to go through the same process since it was in a public place.
In the case of Katz versus United States, Katz was a suspected man of illegal gambling activity who would give out client information. FBI agents put an eavesdropping device on the outside of the phone booth he used. They heard and recorded conversations where he was caught giving out information. While in the court, Katz tried to tell the jury and judge that the recording should not be used because they had violated his Fourth Amendment by setting the device on the phone booth. They ruled against him, saying that the amendment does not protect places and use certiorari.
The judicial branch has the responsibility to rule fairly in cases and to rule in favor of the people. The use of drones, GPS, and surveillance technology is appropriate because all technology is advancing in our world. We do admit there are times when the government takes advantage of all the information they have. And when that happens, we should speak out against it. But we should also know that using our information or seeking a warrant to get our information is necessary.